Welcome to the Pure Legal Guidance Podcast, where we discuss current events and legal subjects. This podcast is presented by Parlatore Law Group, a nationwide cloud-based firm that cuts down on overhead expenses typically associated with traditional brick-and-mortar firms, allowing us to pass that savings on to our clients. We provide high-quality legal services that are accessible and affordable, while freeing up our attorneys to focus on what they do best: provide pure legal guidance to our clients.
All right, welcome to another edition of the Pure Legal Guidance Podcast by Parlatore Law Group. Today I'm joined by partner Maryam Hadden, and we're going to be talking about DNA. So welcome, Mary.
Thank you. See, I got the memo. We're both wearing blue. So.
Yes, we are. So, DNA is kind of, it's an interesting subject, and, before we get into it, just so that the audience, knows your background, it's something you've dealt with, in kind of your prior career. Why don't you talk a little bit about your background, then we'll kind of jump right into the subject.
Sure. So I actually have dealt with it far more in my prior career than my current career at this point. I was a prosecutor in New York City and Queens County, which is one of the 5 boroughs of New York City, for a little over 20 years. And about half of the time that I was there, I was dealing primarily with DNA cases. The city had expanded the cases in which they were doing DNA testing and the cases in which they were doing DNA-based prosecution. And I sort of wound up at the front of that effort for Queens County, at least. So I was involved in the pretty early stages of DNA-based prosecutions and stayed with it on behalf of the office for about 12 years. So I tried many DNA-based cases, did trainings based on DNA, and remained a resource for the office during that period.
It's interesting that phrase you used there, DNA-based prosecutions, because DNA is one of those things that really can go, kind of both ways. It's used by prosecutors, it's used by, the defense attorneys, it's used in appeals. And so before we get to the appeals, let's kind of talk about it from a trial perspective. And of course, now you're on the defense side with us. In the concept of a DNA-based prosecution, I mean, how does that work, really?
So there are a couple of different ways in which DNA can come into play, as you said. And if you're looking at it from a prosecutor's standpoint, it could be additional evidence in a case. Say you have a case where your witness has made a lineup identification, right, or the defendant has made a statement, and then there's also DNA evidence. I wouldn't really consider that a DNA-based prosecution. Then it's just, sort of an extra nail in the coffin. A DNA-based prosecution from the prosecutor's perspective is one where the only evidence you have is DNA, or at least the only evidence of identity that you have is DNA. And that's often the case if you're talking about a property-based crime like a burglary, sometimes robberies, assaults. You may have crimes between strangers where the victim is not able to make an identification, but there was some item left behind with that person's DNA on it, and then a case can sometimes move forward from there, which provides some pretty unique difficulties for a defense attorney.
It does, because it's kind of difficult to say that your guy had nothing to do with it, unless he has an identical twin brother, right, theoretically. But and that's kind of an interesting thing, is especially if you look at TV. You've got CSI and all these other shows that really play up the whole idea of DNA and other, scientific investigative techniques. And, it's kind of created something that we in the defense world call the CSI effect with juries.
Right. And it's actually an effect that, also exists on both sides of the fence, because you do have juries who are really educating themselves, for lack of a better term, just by watching TV. Right. And so they're all thinking that's exactly what DNA is like, or that, somebody from a detective team comes onto the scene and picks up a cloth fiber and says, aha, this cloth fiber only is produced in Bolivia, and so now we know that this one store sells these rugs, and that doesn't happen. And you also don't have a DNA analysis that takes place, in seconds on the crime scene or within a few minutes in the lab. It's a process that takes a lengthy period of time for the most part. But, from the other side of that perspective, scientific evidence in particular, and DNA is the type of scientific evidence that you're going to see most frequently at this point, has been given such a weight of credibility.
Right.
That you really have this real problem in dealing with jurors to, once they hear the word DNA, getting past that and getting them to the point where they can give a fair analysis of the case and the evidence can be very difficult sometimes. So it's something you really have to investigate a lot in your jury selection process.
Sure. I mean, that's become one of the standard questions on the jury questionnaire is, what, do you watch CSI or any of these police procedural TV shows?
Right.
And depending on the case, we either want people like that or we don't.
Right.
I mean, certainly I've tried a few cases where you go through all the DNA that doesn't exist. Well, you never tested this for DNA. You never found any DNA here. You never found any DNA there. And then all those people that are so used to watching that on TV, they think, my God, the police didn't have any evidence.
Right. Oh, absolutely. It's very much something that can cut both ways. And depending on what the facts of your case are and what you're talking about, it can be a huge factor and it can be something that you really need to be concerned about. Sometimes it's not really a factor. If you have a case where identity is not an issue, sometimes DNA really doesn't matter. You may have DNA evidence in a rape case, but if your defense is consent, it doesn't really matter if there's DNA there. Your response to that is kind of like, well, sure, of course his DNA was there. They essentially had sex.
Yeah, I mean, I've certainly seen that, where you have a situation where, you're right, identity is not an issue. The fact that the defendant was there, the fact that, some interaction occurred, and yet the prosecutor still spends a few days going through all of the DNA evidence and having the experts come in and all that stuff. And sometimes you sit there, you listen to it, and sometimes it's boring, sometimes it's interesting, sometimes the jury is really fascinated by it, and then you get up and say, out of curiosity, would that be the exact same result you would find if it was consensual?
Right. Yeah, it absolutely can be something where you can destroy it within a couple of questions.
Yeah.
Or it can be something that's really damaging to your case. It really just depends, and it also depends on how good a job the expert has done of describing it. Some of them are just not good at it.
Right.
So.
Well, and then even within there's different types of DNA. Whether it's, they can tell whether it's from blood or whether it's from skin cells or different things like that that I've seen. And so, even that makes a difference. Oh,
absolutely. And it's the source of the DNA can make a huge difference in terms of the strength of the DNA profile as well. Like you mentioned, DNA from blood, generally your concentration of DNA in your blood is very high, so they can get a clean profile. It's frequently very easy for them to sound, pretty emphatic about, like, this is the profile, this is the person, we're feeling confident about this one, so to speak. Whereas skin cells, on the other hand, it depends on the surface, it depends on whether or not the person who left the DNA is... they call them shedders. Everybody's shedding little bits of skin cells all the time, but different people shed in larger and smaller quantities. So you may be somebody who sheds a lot, and maybe they can get a decent amount of DNA. You might be somebody who doesn't shed very much at all. And then,
something to consider when deciding whether to go into a life of crime. How much do you shed?
Right, exactly. Wash your hands a lot. Don't leave the towel that you used to dry them behind.
Right.
That can be a problem. I've seen cases where defendants have wiped down burglary scenes thinking like, oh, okay, I'm going to remove all my fingerprints. That's great. But then they leave behind the paper towel or the tissue or whatever that they used to wipe away the fingerprints covered in their DNA, probably more DNA than, there would have been if there had been fingerprints. So, in your life of crime, be careful what you leave behind.
So, one thing that I saw it once, and I don't know if you've seen much of this at all, where I had a case where they didn't have somebody to match the DNA to, so instead they tried putting the DNA through, essentially a 23andMe type of a testing. That way they could try and give the jury a profile of, well, this DNA came from a European male with dark hair and, green eyes or something like that. Have you seen that at all?
Really, no.
Yeah.
Because forensic DNA, the locations that are tested for forensic DNA testing, every laboratory across the country will do the testing a little bit differently. And there are different testing kits, but they all test the same locations. And the locations that they test are, they refer to them as junk DNA. So it's not supposed to contain any of that information. That DNA profile shouldn't tell you at all if the individual who left the DNA is white, Hispanic, African American, male, well, male or female, I can tell. But beyond the male or female designation, there's really no information that you can get from the standard DNA profile. The only way that you would be able to take a DNA profile and do what you're talking about, going through like a 23andMe kind of process to come up with racial or eye color, hair color, those types of characteristics, would be if you had a more complete DNA profile and if you had obtained probably court permission to be able to run an analysis that the DNA laboratories ordinarily don't run. That's actually one of the things that they're supposed to be, in order to comply with the statutes, very careful about, is not to test for those characteristics because there are real privacy concerns involved.
Oh, interesting. Yeah, in my case, they did that testing, and ultimately it wasn't ruled admissible because the 23andMe type company that did this testing refused to reveal their proprietary techniques to the court, and so therefore the court couldn't determine whether they were reliable or not.
Right, and that is another aspect of DNA testing, because there are so many different types of tests out there and different analyses and analytical kits. Each one has to go through sort of court approval before it can be used. So there are a number of approved programs out there that are used by most of the forensic laboratories. But anytime you have somebody being, kind of extra creative, like the case that you described, they do have to go through court approval in order to get that into evidence, and that's frequently a hurdle that they can't quite leap.
The prosecutors in that case, parenthetically, were extra creative. Not just in that one instance, but turning gears a little bit, DNA is also something that's become very big in the appellate world over the last several years, and this is kind of where we end up seeing decades-old cases all of a sudden coming back and getting overturned is through DNA evidence.
Right.
And the thing that a lot of people look at it and they say, well, it's been so long. Yeah, are there statutes of limitations? How does that work?
So it really is somewhat state-specific, but most states do have some statutory structure that will extend the statute of limitations where DNA is involved. In New York, for example, the ordinary statute of limitations for a felony is 5 years. But there is a statutory provision that says if you don't know the identity or the whereabouts of the perpetrator, the statute of limitations can be extended up to an additional 5 years. So essentially, in a DNA-based case, like a burglary or robbery, such as I was discussing earlier, you have a 10-year statute of limitations in the state of New York instead of a 5-year statute of limitations. So in that sense, there are certain expansions, and that again, changes from state to state. The numbers may be a little bit different, but most states do have a similar provision where they will let you look further back if you're just discovering the identity of the perpetrator of the crime.
I hadn't even thought about that side. I was thinking about from the post-conviction. You normally have to file a notice of appeal within 21 days.
Right.
Versus all of a sudden 20 years later.
And that's sort of where the other aspect comes in. So another thing that most states do have at this point, I haven't checked all 50, but I don't see any reason why there would be a state without it. But each state will have a statutory provision that allows a defendant to, kind of look back, get that DNA evidence if they can show something to say that the testing wasn't available at the time that they were being prosecuted, and that they weren't given the evidence at the time that they were being prosecuted. And because DNA doesn't really expire, it's not like a carton of milk that's going to go bad. So you can look back decades and have DNA tested. The only thing that can impact that is the way the DNA was stored. So say you have a bloody piece of clothing from a crime scene. If that clothing was stored properly, you could be able to get usable DNA off of it 20, 30, 40 years later. If it was not stored properly, you may still be able to get some DNA evidence from it. And in the case of a defendant who's trying to exonerate himself years down the road, even a partial profile might be enough if you're able to say, like, well, it's not this guy because it doesn't match this particular location on the DNA profile. So you don't necessarily need a full profile in order to exonerate somebody. You really just need to have one difference, and one difference is enough. But you do have to have enough DNA there to be able to get, at least something that you can then compare to the defendant's DNA.
And interestingly, different prosecutors' offices take very different views on this subject. I've seen some where they actually, create a conviction integrity unit where they work with the Innocence Project to go ahead and test these things. And I've seen others that are, vehemently opposing it, and they say, no, the conviction is final. We should not be going back and testing it. Just accept the fact that you get convicted and spend the rest of your life in jail and be happy about it. I mean, that always struck me as one of those things where, like, if you have somebody, especially like a death row case, if you have somebody who's sitting there saying, I'm innocent, the evidence to prove that I'm innocent is sitting in that box over there, will you just let me open the box and test it? And it always strikes me as odd that a prosecutor would fight so hard to, no, don't open the box, don't take a look. Whereas the flip side of that is, hey, if he really did it, open the box, take a look, have the test prove that, yep, you're the guy that did it. Okay, let's get the needle and, go straight to the end line now.
Right. And that's, you and I have spoken before about how important ethical conduct is for prosecutors, and that really is where that kind of thing comes into play, because it really will start, each individual prosecutor's office is run by the district attorney of that office, whether it's 3 people or 300 people. And it's really a top-down kind of thing from the district attorney, whether or not it's something where they're focused most on doing the right thing, or focused most on protecting whatever the conviction record may be. And unfortunately that changes from office to office and elected official to elected official. But yes, there definitely are differences in the way that it's sort of dealt with across the board. The one advantage of having those statutes out there, though, is that even if the district attorney's office in your locality is fighting it, many states have a statute that as long as you can establish some reason to believe that opening the box is going to have some useful evidence in it, you will eventually be able to open the box. It's more a question of how much of a fight are you going to have to go through to get there.
Yeah.
And some people have the resources to fund that kind of a fight, and some people don't.
True. And sometimes elections change things. I had a client.
True also.
I had a client years ago that I represented his family because they had fought for years for his exoneration, and the DA at the time, Hines, in Brooklyn, fought hard against it. And then Hines lost his re-election campaign. Ken Thompson came in, and he had a totally different view on how to do things. And Ken Thompson immediately reached down and said, oh, no, we want to test this. We want to take a look at it. And so all of a sudden it went from this adversarial proceeding where the DA was adamantly opposed to a few months later where Ken Thompson himself, the DA, stands up in court and makes the motion to dismiss.
Right.
Yeah, it was absolutely wild.
Right. No, absolutely. Elections can make a huge difference, and it's because of that, top-down mentality where it really is the person at the top deciding how they want their office to be run. I was fortunate to work in an office where do the right thing was sort of the guiding principle. Not sort of, it was the guiding principle. That was what the DA said.
Some people even listened.
Most of us listened. But that certainly isn't the case in every office. So it really is something that can make a real difference. It can very much be luck of the draw depending on where you are and when you're there. And also just whether or not you're even aware that that box is there to be opened. Sometimes that's something that can be missed by an attorney early on, and it may not be until years later that somebody catches it.
That's true. I mean, I remember that was one of those things that I always had such respect for Ken Thompson because of what he did in that case. And there's a recording of this. Everybody knows I just said something nice about a prosecutor.
I'll write it down. And it wasn't me.
So yes, DNA. It's an interesting topic. Moving it to another context, though, what about in civil cases? I mean, if you have a civil case, do you have access to be able to test this stuff, or is that solely within the province of the government?
Well, that I can answer more in New York than anywhere else. In New York City, the Office of Chief Medical Examiner is responsible for testing all of the DNA evidence that comes in. And they're an independent agency. They're not an arm of the prosecutor's office or the police department or anything like that. So they absolutely
I know, they always
test.
say that during cross-examination.
If you look at their, top-down structure, it's accurate. So, but yes, they will test for a civil case, or you can obtain results that have already been done for a civil case. Ordinarily, when the property comes in to be tested, it will be tested. It's a question of how quickly, depending on the type of offense that it's designated as belonging to, and how backlogged they are.
Right.
But it is certainly possible to do that, and there are other private laboratories around the country that will also test it. If you're not able to have a state-run laboratory do it, you can always have a private laboratory do it. But again, that's a question of having the funds available. You may have someone who's able to retain private counsel and able to pay for a private laboratory. You may have somebody who's kind of lucked into being represented by a project or a fund that is willing to take on that expense as well, or you may have somebody who's indigent and not able to take those kinds of steps.
Yeah. Well,
although in the civil case, I guess you've got fewer indigent people bringing cases.
Unfortunately. So DNA, it's a fascinating, topic, and it has a lot of positives. It has certain negatives, and ultimately, at the end of the day, hopefully, if used correctly, it furthers the goal of justice.
Absolutely, and that's the advantage of DNA is that it is impartial. It's the ultimate impartial evidence. It is what it is. You can't change a DNA profile into someone else's DNA profile. Even in that case we spoke about earlier where evidence has been stored improperly and maybe the DNA profile has decayed, that doesn't change it from one profile to another's. It's never going to change my DNA profile to your DNA profile. But what it will do is it will just give you less to work from. So it'll still be my profile, there just might be less of it there.
Yeah.
But because it is impartial, that means that it really can sometimes provide that evidence and that certainty, either in favor of acquittal or in favor of conviction, that you won't get from something like, an eyewitness identification or a confession, even videos, depending on the video or the picture. As everybody knows, you can take a videotape that looks beautiful from a particular angle and it shows something completely different if you're on the other side of the camera lens. So that's the one way in which DNA can be sort of an evening factor for both sides.
Yeah. Well, thank you so much. Are there any other closing remarks about DNA?
Now I'll tell you my one fun fact is that identical twins have the same DNA profiles as you mentioned, right at the beginning, but different fingerprints. So
really,
yeah, that's my fun fact of the day.
That I didn't know. Well, thank you so much for joining us, and
You're
this
welcome.
has been a very interesting conversation about DNA, one of the major factors in a lot of court cases today. So. Thank you all for joining us for another episode of Pure Legal Guidance Podcast by Parlatore Law Group.
The views expressed by both attorneys and guests of this podcast are their own and do not necessarily represent the views of the firm. The information presented here is for informational and entertainment purposes and is not intended to constitute legal advice or to replace a consultation with an attorney. Listening to this podcast does not create an attorney-client relationship. For advice on your individual situation, contact us to set up a consultation.